If you're dealing with a loved one's estate in Florida, you may be asking, what happens to a homestead property in probate? Does homestead avoid probate? And who actually inherits a Florida homestead? Florida homestead law is one of the most misunderstood areas of probate, and getting it wrong can lead to delays, disputes, and unexpected outcomes. In this video, I'm breaking down the complete guide to Florida homestead in probate, including what it is, how it's treated, who inherits it, and what you need to know to avoid common mistakes. In Florida, homestead refers to a person's primary residence that receives special legal protection under the Florida Constitution. But it's not just a label, it carries significant legal consequences. Homestead property may be protected from certain creditors, has strict inheritance rules, cannot always be transferred freely through a will, and requires special handling during probate. To qualify as homestead, the property must have been the decedent's primary residence at the time of death. So that means investment properties do not qualify, rental properties do not qualify, and second homes typically do not qualify. So one of the first questions in probate is actually, was this homestead property? One of the biggest misconceptions is that homestead avoids probate entirely. The answer is not exactly. Homestead property may pass directly to heirs by operation of law, but the probate court still has to confirm that the property qualifies as homestead. They have to determine who the legal heirs are and enter an order transferring ownership. So this is usually done through a petition to determine homestead status. So while the homestead may avoid being used to pay most creditors, it does not avoid the probate process altogether. Think of it this way. Probate is still needed to legally establish ownership, even for homestead. Florida homestead inheritance rules are very specific and they can override a will. If there is a surviving spouse, the spouse typically receives a life estate in the property, or they have the option to elect a 50% ownership interest as a tenant in common. The remainder interest typically goes to the children. If there is no surviving spouse, the property generally passes to the decedent's children. Here are some important considerations. If there are minor children, the homestead cannot be devised freely. So if a will attempts to transfer homestead improperly, Florida law overrides that will. And blended families can create complex issues. This is one of the most common areas where families are surprised. In most Florida probate cases involving real property, a petition to determine homestead is filed. This petition asks the court to confirm that the property qualifies as homestead, identifies the legal heirs, and determines that the property is exempt from creditor claims. Once the court enters this order, ownership is officially transferred to the heirs. Without this step, you may not be able to sell the property, refinance it, or clear title. So this step is critical in real estate transactions. Florida homestead property is generally protected from most creditor claims. This is one of the strongest homestead protections in the country. However, there are some very important exceptions. Mortgages and liens on the property, property taxes, and contractor or construction liens. So while homestead is protected, it's not completely immune from all claims. The probate court still plays a role in confirming that protection. Another common question is, can you sell a homestead property during probate? Generally, the property is not sold during probate itself. Instead, the court determines homestead status, ownership is transferred to the heirs, and then the heirs decide whether to sell. If multiple heirs inherit the property, all owners need to agree to the sale, or additional legal steps may be required. And this is where disputes can arise. Here are some of the most common mistakes. Assuming homestead avoids probate entirely, trying to sell the property before ownership is transferred, misunderstanding a spousal and children's rights, failing to file a petition to determine homestead, and overlooking how blended families affect inheritance. These mistakes can delay probate and create unnecessary conflict. Homestead issues can become complicated very quickly, especially when there's a surviving spouse and children, there are multiple heirs, the will conflicts with Florida law, the property needs to be sold, or there are disputes between family members. Getting guidance early can help ensure the process is handled correctly. Hi, I'm Alicia C. Daniel, Trust, Estate, and Probate Attorney at Genesis Law. If you need help handling homestead property in a Florida probate matter, click on the link in the description box or my bio and select Schedule a Consultation.